Hello, this is Professor James Strickler, and this is a course in American government. This lesson is from Unit 8 about civil liberties. It's Lesson 8 about limits on speech. In this lesson, you'll learn about unprotected speech. You'll learn about symbolic speech, also known as expressive conduct. You'll learn about the Supreme Court case Tinker versus Des Moines, the Supreme Court case Texas versus Johnson, and the Supreme Court case of Barnes versus Glenn Theater. In a previous lesson, you learned that civil liberties are not necessarily absolute. In other words, there may be some point beyond which you can take some particular freedom, whether it be freedom of speech or freedom of religion or whatever it is, where most people would say, all right, you've gone too far, such as, for example, using religious freedom to conduct human sacrifice, or using free speech to reveal secrets during a time of war. You also at that time learned that it's the Supreme Court that decides wherever this line is, beyond which you go too far. So if you try to figure out, well, just what can I say before I've said too much, it's the Supreme Court that decides that. In that lesson, you also learned that the way that the Supreme Court claims to decide where it's going to assign the line of these things is based upon a couple of tests called the compelling interest test and the rational basis test. Basically what the Supreme Court does when a civil liberty is in dispute is they decide whether that civil liberty is what they call a fundamental freedom or a non-fundamental freedom. And then, based on that, if it's a fundamental freedom, they say that the government has to have a compelling reason to deprive you of that freedom. If it's a non-fundamental freedom, they say the government only needs a rational basis to deprive you of that freedom. So oftentimes, what decides whether or not a liberty is protected or not is simply whether or not the court characterizes it as fundamental or non-fundamental. If it's non-fundamental, the government's going to have a very easy time reaching that rational basis standard and then being able to infringe upon that freedom. If it's fundamental, then the government's going to have a very strict test to pass, the compelling interest test, which oftentimes they're not going to be able to. So based on those tests, we learned that the Supreme Court effectively can create, define, and even destroy rights, depending on whether they say they're fundamental freedoms or not, depending on whether they say the government has a compelling reason or not, etc. These decisions by the Supreme Court define our rights for us. And we're going to look at an example of this by considering how the Supreme Court defines freedom of speech. Now, here's the passage from the First Amendment where it says, Congress shall make no law abridging the freedom of speech. I think if we were to ask most Americans, they would say that freedom of speech is a fundamental freedom, one of the most basic rights that we have. And the Supreme Court would agree with them. It has generally always said that freedom of speech is one of our most important freedoms. It is a fundamental freedom. Therefore, it would be deserving of the compelling interest test. But that doesn't tell us what speech is. Maybe speech is protected at the compelling interest level, but what is speech? The Supreme Court, in some cases, has declared that some speech is in fact not protected by the First Amendment. Now please, understand what I'm saying here. We could have a situation where someone is actually speaking, words are coming out of their mouth, and the Supreme Court says, no, that's not speech. What do you mean that's not speech? The person's actually speaking. Well, it's not speech as that is considered under the First Amendment. So it's unprotected speech. Well, what exactly is unprotected speech then? Okay, we got this general category that there are some forms of speech that are not protected, but what are they? One example from the Supreme Court is commercial speech. Now, when I say commercial speech, it's just what you think of as commercial speech. It's a commercial, an advertisement. Speech that's proposing some sort of transaction, buying, selling, that sort of thing. The Supreme Court has said that that is not protected by the First Amendment at the same level as, say, political speech is. Another form of unprotected speech, according to the Supreme Court, is slander or libel. That's when you tell a lie about someone and you know it's a lie, but you're doing it to hurt them. Now, the photo here on this slide is of a celebrity couple, Tom Cruise and Nicole Kidman, who at one time were married. And there was a newspaper that published an article claiming that their marriage was a sham, that Tom Cruise was actually gay and the marriage with Nicole Kidman was just a fake in order to get people to not realize he was gay, etc. So they published a story like that. Tom Cruise sued them, and he actually won in court. He was able to establish that they were telling this to hurt him, and they had a disregard for whether it was true or not. They just wanted to cause him trouble. A third example of unprotected speech is obscenity. Now, what is obscenity? In a way, that's kind of a trick question that I'm asking you. In general, it's something that's really offensive to whatever the prevailing morality is. But what is that? That's still a very vague term to say. The reason I said it's kind of a trick question is because the Supreme Court's even had a hard time defining obscenity. At the same time, they're saying that obscenity isn't really speech and therefore not protected by the First Amendment. You have justices say things like this, I know it when I see it, speaking of obscenity. So they have a trouble defining it, but they know it when they see it. Well, as a result, the Supreme Court for many years had to case by case decide whether something was obscene. Because if it was obscene, then it's not speech according to them, at least not speech under the First Amendment. Therefore, it's not protected by the First Amendment, and the government only needs some sort of rational reason to infringe upon it. But if it is speech, then it's a fundamental freedom, and the government would need a compelling interest to take it from someone. So, whether a thing is obscene or not could make a big difference on whether or not the person doing that thing can be arrested, thrown in prison for it, or whatever. And the Supreme Court would decide these case by case. A case would come before them, they'd have to look at the material involved and decide, is this obscene? A common sort of case that came before them at this time dealt with pornographic movies. So somebody would set up a theater, for example, and they'd start showing these movies. And then the cops from the local community would decide it was obscene, offensive. They'd show up and arrest them, confiscate the movies, whatever. The whole thing would go to court, and it would end up in the Supreme Court. And what the Supreme Court would basically have to decide is this movie obscene or not? If it's obscene, then it's not protected, then the arrest of this person, the confiscation of the movie, whatever it is okay. If, on the other hand, it is not obscene, then it's potentially a act of free speech. It's a fundamental freedom. The government would need to have a compelling interest to stop them, and it's going to be a lot harder for the government to prove that they should be arresting this person. So whether or not it's obscene or not is going to make a big deal. So the Supreme Court had to case by case, movie by movie, decide whether or not something was obscene. So once a term, okay, I'm telling you the story, you're going to think that I'm making this up, but it's really true. They would have what they called movie day at the Supreme Court, where they would set up a projector in the basement. They would start watching these potentially obscene movies. They'd pop popcorn. The justices and their clerks would sit around and watch them. And after each movie, they would essentially take a vote. Hey, who thought that was obscene? And in that way, they would decide whether or not these people had constitutional protection or not that were engaged in these activities. Okay, so at the same time, Supreme Court is taking some categories of things where people are actually talking, and they are then deciding, oh, but that's not speech, so it's not protected by the First Amendment. The Supreme Court was also taking situations where no one is talking, and nonetheless calling those situations speech that is protected under the First Amendment. This nonverbal speech is what we can call symbolic speech. That's a term the Supreme Court actually uses to describe such things. Another term they use for it is expressive conduct. What symbolic speech or expressive conduct is it's some sort of action that's intended to convey a message that is likely to be understood. So you're doing something, you're not speaking, but you're doing something that people will recognize as you communicating a particular idea to them. One example of this was the Supreme Court case of Tinker versus Des Moines, where some students wore black armbands to school to protest the Vietnam War. They were kicked out of school for violating the dress code. Eventually, their case went away to the Supreme Court, and they won. The Supreme Court said that wearing the armbands was freedom of speech. Now, please notice, the students were not actually talking. They were just wearing an item of clothing. Yet, the Supreme Court said that item of clothing was effectively speech and was therefore protected. Another example is in the case of Texas versus Johnson, where a man at a protest at a political party convention burned an American flag and was arrested for it. That case went to the Supreme Court, and the Supreme Court ruled that burning the American flag was an act of free speech. They said that the person burning the flag is conveying a message that they hate America. It's likely that the message will be understood, therefore it's free speech, and it's protected by the First Amendment. And Texas would need a compelling reason to stop Johnson from doing this, which they said Texas didn't have. Now, you may wonder, why wouldn't Texas have a compelling reason? What about protecting patriotism, all that kind of thing? Supreme Court said that's not good enough, because a basic idea of our country is that we should be able to stand up against the government and protest it. And so it's not a compelling reason for the government to shut down people who are criticizing it. The third example of symbolic speech is from the case of Barnes versus Glenn Theater, where the Supreme Court ruled that nude dancing is free speech. The Supreme Court actually said that nude dancing is conveying an erotic message. So they said that is free speech, and so the government would need a compelling reason to prohibit it. So what you should get from these cases is that the Supreme Court, by deciding whether a thing is speech or not, is deciding whether it has constitutional protection. And it's really kind of up to them whether they think something is speech and therefore should be protected. Let's review what we learned in this lesson. Which is an example of unprotected speech? In other words, speech the Supreme Court has said is not speech. Is it politicians telling lies? Is it racial insults? Is it Super Bowl advertisements? Or is it people complaining about Congress? The one example here that they would consider to be unprotected speech is Super Bowl advertisements. This is commercial speech. What the Supreme Court has said, if it gets any protection, it's much lower than what normal speech gets. So it's not protected in the same way as, for example, complaining about Congress would be. What is symbolic speech? Is it actions to send a message? Is it written language? Is it mathematics? Is it sign language? Symbolic speech, as the term is used by the Supreme Court, refers to actions that are intended to send a message, such as burning a flag as part of a political protest. What did Tinker versus Des Moines rule? Did it rule that libel is not protected, that protesters can be arrested, that there's no free speech in school, or that wearing an armband is an act of speech? In Tinker versus Des Moines, they ruled that wearing an armband to protest the Vietnam War specifically was an act of free speech. What did Texas versus Johnson rule? Did it rule that conventions, political party conventions, are open to the public? Did it rule that protesters at such conventions can be arrested? Did it rule that burning a flag is obscene? Or did it rule that burning a flag is an act of free speech? Burning an American flag is an act of free speech according to the Supreme Court. What did Barnes versus Glenn Theater rule? Did it rule that nudity isn't expressive conduct? Did it rule that public nudity is illegal? Did it rule that nude dancing is obscenity? Or did it rule that nude dancing is speech? Barnes versus Glenn Theater ruled that nude dancing is speech and therefore protected by the First Amendment. That completes this lesson. The next lesson will also be from Unit 8. It'll be Lesson 9 about limits on religion.